So, before apply for registration, registration basically not an appropriate word here. Registration word we attach with the partnership firm. With the companies we use word incorporation. But as a ordinary parlance or in a ordinary sense, we generally majority of the cases use word company registration. So, you not confuse about the same. Registration and incorporation generally both are same, and registration is a general word which touch our ordinary parlance. So, Memorandum of Association as defined in section 4 of the Companies Act 2013, that is a very important document, and this document is treated as constitution of the company, and this is also treated as charter of the company. And how much importance of this document you judge from the same, if a company enter into any contract against the clauses of Memorandum of Association, that type of agreements treated as null and void. They are ultra vires, beyond their powers. So, majority of the jurists in the favor that Memorandum of Association contain 5 clauses. But some jurists also in the favor that there are 6 or 7 clauses, and we discuss later on in the chapter of Memorandum of Association how we draft, what's the formalities we need to be fulfilled before apply for registration of Memorandum of Association. But majority 99% jurists in the favor that Memorandum of Association contain 5 clauses, and very first is here name of the company. Name of the company is the very important aspect here. You just imagine if there is a person and there is no any name of the person, it means name basically the symbol of existence, and without name when a person not survive, not working in the civilization, not properly work in the society, the same system is applicable with the companies. Without the name of company, there is no any meaning of the company, and along with this name clearly mention limited liability company or public limited company, which type of companies, or unlimited liability company, name clearly mention. And second clause is here registered office clause. Registered office means one office designated as registered office of the company if company have more than one office. This registered office we require to maintain the communication with the company, and without this registered office it is impossible to maintain the communication with the company. So, registered office is also play an essential role in case of Memorandum of Association. Third, object of the company. Before 1960 we incorporate with one object, but after 1960 we are allowed to be incorporate with the 3 different type of objects. One is known as main object, second incidental object, third other objects. Why we required these type of objects here? Because due to some government policies or due to some developments, if it is not possible on the part of company, they run with their main object, then they allow to be shift their business in ancillary objects, in other objects. Company remains survive as it is, and in the meantime company shift their business from main object to ancillary object. And fourth here liability. Liability basically means liability of members. How much liability? Unpaid share part. If company is limited liability, then up to unpaid share part. If company is limited by guarantee, it means you need to be pay this guaranteed amount at the time of call or at the time of winding up, whichever is earlier. At that time you need to be pay this amount. Fifth clause is known as capital clause. In this competitive era and in this business scenario, you just imagine we not survive any business without capital. Capital is an essential part of the business, and majority of the cases company incorporate with the capital. but in some cases companies are also allowed to be incorporate without capital. So, capital clause basically indicate that entire structure of capital which hold by company. Capital clause is the only clause which changes, or you maybe say altered with simple resolution. Otherwise, in the rest of the clauses, here we required, in case of name we required the special, in case of registered office we required the special, in case of object we required the special resolution, in case of liability we required the special clause, special resolutions. Special resolutions very important for rest of the purpose. Memorandum of Association of the companies, which deals by section 4 of the Companies Act 2013, that's clearly defined. Rest of the clauses except capital clause we altered or changed with special resolution. Only and only capital clause we altered or changed with the simple resolution. Rest name clause we changed with the special resolution. Registered office clause we changed with the special resolution. Object clause we changed with the special resolution. Liability clause we changed with the special resolution, but only capital clause only allowed to be changed with the simple resolution. Form, which type of forms applicable with the Memorandum of Association? If the association not interested to draft their Memorandum of Association, then this facility provided by Companies Act 2013 in Schedule 1. If you adopt form number A, table A, B, C, D, E, these 5 tables for different type of companies, if they are not ready to prepare their own Memorandum of Association, they may be adopt this model Memorandum of Association, fill up the name of company, that's treated as their own Memorandum of Association. And Memorandum of Association must be printing and sign. Memorandum of Association should be divided into paragraphs and numbering should be there. Paragraphs and numbering, that's the requirement of law. Memorandum of Association should be signed by the subscriber. I already explained here, subscriber means number of person, minimum number of persons who sign on every document before submission for incorporation, they are known as subscriber. And once a company incorporate, they become the member. Before incorporation they are subscriber, and after incorporation they become the member. And along with their name, address and occupation should be mentioned against their number of shares which they agree to buy after incorporation. So, their entire detail should be witnessed by at least one witness. One witness should be attest their own signature and their detail.